So you got a trust many years ago. You checked the box, moved on. But the problem is, if you haven't updated it, it could be making things much worse for your family. We've seen it happen countless times. Families blindsided by outdated documents, missing beneficiaries, legal battles, massive legal headaches, and it could all just be avoided. Let's talk about how to make sure that doesn't happen to your family. Hi, I'm Erin of Truly Aligned.
And I'm Maximilian of Truly Aligned. We had a client that were referred to after both of their parents passed away unexpectedly. Her parents had saved diligently for their own retirement. Shortly after retiring, they unfortunately both passed away. Their daughter, who was a trustee, spent countless hours dealing with all of the legal mess that was created, as they did have a trust in place, though their assets were not moved into the trust because it was set up decades ago. That is the reality when estate plans don't get properly updated. And the worst part, it was 100% avoidable.
So today we're going to talk about what you need to do to make sure that your family doesn't end up in a situation similar to this. The first is to understand what documents you need and what they actually do. Estate planning isn't just about where your money goes. It's about making things easier for the people you love when they need it the most. If you don't have these basic documents in place, or they are outdated, you're leaving your family with more stress, more costs, and more time in probate court. So the first document is a will. A will states who gets your assets and who is in charge of handling your estate after you pass. A will does not avoid probate court. If your will is your only estate planning tool, your family will still have to go through probate court to distribute your assets.
The next part of getting an estate in place is a trust, and the trust is the most crucial part to avoid probate court. A trust is a legal entity that holds your assets and determines where those assets get distributed upon your passing. Trust helps your family access your money, your investment accounts, the ownership of your house immediately upon your passing without dealing with the hassle of probate court. But a trust only works if your assets actually get moved into the trust. Not moving your assets into the trust is like having a safe and not moving your valuables inside the safe. This is a huge mistake that we see people make. They think I'm good, I've set up the trust, but they've not done the actual steps in order to make that trust possible. As an example, when you own a home, you have a title and a deed, and that ownership is in your name. The crucial part is to put that into the trust, so upon your passing, your beneficiaries can avoid probate court and the hassle of dealing with that.
The next document to be aware of is a power of attorney. This is who's in charge when you cannot be. A power of attorney gives someone legal authority to handle your finances if you become incapacitated. This can help you avoid court-appointed guardianship or conservatorship. But your power of attorney must be legally valid and up to date. Banks and institutions may reject out-of-date power of attorney. You can think of it this way. If something happens to you tomorrow, who's going to be stepping up to handle your bills, access your accounts, and just keep things running in your life? If you don't have a power of attorney in place, your family might have to go to court just to get permission to handle basic financial tasks.
The next step in getting your estate in order is a healthcare directive, also referred to as a living will and medical power of attorney. A healthcare directive states who can make decisions for you if you have a medical issue where you're incapacitated or unconscious. It outlines the healthcare that you want or don't want. Do you want artificial nutrition to prolong your life? Do you want to do organ transplant? It outlays all that information. Additionally, this only works if your loved ones know this exists. So please make them aware of it. Without your loved ones knowing this, they can be making difficult medical decisions that may not be in alignment with what you wanted. And at times, it can lead to people fighting over what medical decisions to make.
The next important document to know about is the guardianship designation. This is who takes care of your kids. If you have minor children, this names their legal guardian if something were to happen to you. Without it, the state will decide who raises your kid. This one is huge, especially if you have specific wishes for how your kids are raised or who should step in when you're gone. Don't leave this one up to the court.
Next thing you need to do is check your assets, making sure that your assets are in alignment with what the attorney recommends, meaning your different investment accounts are actually held by the trust. The deed or title of your house is held by the trust. Double check to make sure that all of your beneficiaries are correct on your investment accounts, savings accounts, etc. If you miss this step, your assets will not be in your trust, and this could add a huge hassle for your loved ones to go to probate court.
Next, it's very important to talk with your family. You don't have to tell your kids everything, but you do have to let them know where documents are located and the important information if you're unable to tell them in the future. Things like who is your estate planning attorney, who is your financial advisor, where are accounts located, and what are your login information for those accounts, and any special instructions about your assets and care. We see this all the time. Parents think, my kids will figure it out. But when the time comes, what if your kids don't know where to start? This is really where it tends to get messy.
The next step is to get organized and make sure that your beneficiaries have access to your will, your trust, your healthcare directive, all of the information that is needed for the estate. That's the most important part. Additionally, making sure they have contact information of your trusted financial professionals, whether that's your CPA, wealth advisor, or attorney. Additionally, we find it really helpful to have a list of all of your login information so they can easily access your accounts. This isn't just for you, it's for your loved ones, it's for your family, it's for your beneficiaries. Make sure they know exactly where things are if something happens and they have the proper contact information to make their life easier.
The next step is to work with a professional, whether it's having an estate planning attorney review your trust or working with a wealth advisor who has those services. Your life is changing all the time, so it's important to have your estate plan reviewed to make sure it's still in alignment with your wishes and desires. At Truly Aligned, we work very closely with an estate planning team to make sure that our clients have a very proactively structured trust to make sure that it stays in alignment with their desires and goals before something happens.
So, as far as the next steps in the process, number one, have a conversation with your beneficiaries, your loved ones, and your family. Number two, make sure you're organized and share all that information with your beneficiaries. Number three, if it's been many years since your estate's been updated and your life has changed a lot, contact a professional to make sure that everything is in accordance and get it reviewed and updated. If you want to make sure that your estate plan is rock solid, feel free to schedule a consultation with us. Link in the description below. Till the next time, stay aligned.